If you were unconscious in a hospital bed and couldn't speak for yourself, who gets to decide whether you stay alive? This question reached the Supreme Court of Canada in Cuthbertson versus Rasouli in 2013. In 2010, 61-year-old Hassan Rasouli underwent brain surgery in Toronto, and after complications, he suffered severe brain damage and became unconscious, kept alive only by mechanical ventilation and artificial nutrition. And without this life support, he would die. His doctors believed he was in a persistent vegetative state, that treatment was ineffective, and wanted to withdraw life support and move him to palliative care. But his wife, which is his legal substitute decision maker under Ontario's Healthcare Consent Act, refused. She believed, based on his values religiously, that he would want to be kept alive. This created a direct conflict between medical judgment and family decision making, in a situation where the patient could not speak for himself. The key legal question was whether withdrawing life support counts as treatment under Ontario's Healthcare Consent Act. The Supreme Court, in a 5-2 decision, said yes. The court interpreted treatment broadly as anything done for a health-related purpose. That includes the individual acts involved in withdrawing life support itself, because it involves actions taken for a health-related purpose, including palliative care at the end of life. So if doctors believe treatment is medically ineffective, they still need consent before withdrawing it. That means doctors cannot unilaterally withdraw life support. If consent is refused, the dispute must go to the Consent and Capacity Board, which is a specialized tribunal in Ontario. The board can override the decision maker if it finds that they are not acting in the patient's best interest under Section 21 of the Act. 2 justices dissented, arguing these decisions belonged in a court under common law, not before an administrative board. But the majority decision is what governs in Ontario today. This case directly affects you. If you lose capacity, someone else will make medical decisions for you. The law sets out who that person is, typically your spouse or partner first, then an adult child, then a parent, then a sibling. If you haven't formally chosen someone, the law decides it for you using a set hierarchy. That person, your substitute decision maker, must follow your prior expressed wishes if you made them while capable. If your wishes aren't known, they must act in your best interest based on your values, beliefs, and medical condition. In this case, Mr. Rasouli had no clearly documented wishes, and that is what caused this entire legal conflict. So the most important takeaway is document your wishes while you are still capable. That can mean naming someone you trust in a power of attorney for personal care, or simply having honest conversations with your family about what you want. This case also protects you because it ensures that no doctor can make this decision alone. There must be a legal process that includes the people who know you best. This case also reshaped how the healthcare system handles end-of-life decisions. It moves decision-making away from individual physicians acting alone and into a regulated legal process through the Consent and Capacity Board, bringing medical judgment, patient autonomy, and family involvement together under one framework. In my view, rooting these disputes through the CCB rather than courts is the right approach. It's faster, more accessible, and the board has genuine expertise in exactly these situations. But the ruling also exposes a real gap. This framework only applies to Ontario. Patients in other provinces don't have the same structured protections, and Canada still lacks a consistent national standard for end-of-life decision-making. There are also ongoing tensions this case didn't fully resolve around the ethical strain on doctors required to continue care they consider harmful, and the resource pressure on ICUs when disputes drag on. At the end of the day, Cuthbertson versus Rasouli shows us how law, medicine, and deeply personal values intersect. And just in case something happens, your wishes should be on record.